Thank you for your interest in United States patent post-grant proceedings. The following presentation is excerpted from a recorded webinar that is part of an ongoing educational series offered by Fitch, Tabin and Flannery. For more information about Fitch Even's webinar offerings, please visit our website, www.fitcheven.com. My name is Dave Gussie. I'm a partner and a member of the PTAB practice group at Fitch Even. This presentation includes a brief summary of the three types of trial proceedings available under the 2011 America Invents Act, including inter partes reviews, or IPRs, post-grant reviews, or PGRs, and covered business method patent reviews, or CBMs. Each of these trial proceedings takes place at the United States Patent and Trademark Office, or USPTO, before the Patent Trial and Appeal Board, for short, the PTAB. So the PTAB trials in general, each of these three procedures, inter partes review, covered business method proceedings, and post-grant review, have very similar procedure. There's some minor differences among them, which we'll talk about, but we're going to talk also broadly about the similarities. Each of these is effectively a simplified procedure. PTAB trials are statutorily limited to taking only 12 months from the institution to a final decision on the merits, and this is effectively the major innovation relative to the earlier inter partes reexamination procedure. Those inter partes reexamination proceedings tended to last almost indefinitely, with numerous amendments and back and forth between both the examiner, the requester, and the patent owner. PTAB trials are also beneficial because they're streamlined relative to district court litigation. You have a streamlined discovery and briefing schedule that helps maintain that statutory 12-month period. These PTAB trials are also advantageous because third party remains active in the proceedings. So relative to ex parte reexamination, where only the patent owner is able to communicate with the examiner, these PTAB trials allow the third-party requester to respond to the arguments that the patent owner makes and change their arguments as needed to reflect the patent owner's new arguments. At the same time, they are simpler, shorter, and less expensive than full-blown district court litigation between the parties, so they're advantageous in that respect as well. Now, the trials are ultimately decided by 3 administrative patent judges. Those judges have technical and law degrees, so they are quite experienced and capable of responding to patent issues, both on the technological side and also on the legal side. Typically, those judges also have experience as patent examiners or as patent attorneys or litigators, so they know their way around. The trial proceedings proceed in sort of a 2-stage process. There's a petition or preliminary phase, and then if the trial is instituted, it moves into a trial phase, and we'll discuss that next. On the screen now we have a timeline for the typical PTAB trial. Institution decision, there's starting with the petition. Petition is filed, and from that time forward, there's 3 months for the patent owner to file a preliminary response, and after the preliminary response, there's a preliminary decision on institution that happens within 3 months of that. So just a little bit over 6 months after the petition is filed, you typically have a decision on institution. And that decision is based on a standard that differs a little bit among the different trial proceedings. In an IPR, the decision is based on whether or not the petition has shown a reasonable likelihood that the petitioner would prevail with respect to at least one of the challenged claims. In a PGR, a post-grant review, or a covered business method review proceeding, the board will institute trial when the petition shows that it is more likely or not more likely than not that at least one of the challenged claims is unpatentable. So the standard is a little bit looser for post-grant review and covered business method review. It just requires more likely than not, as opposed to an IPR where there has to be a reasonable likelihood, which most people think is just a slightly higher standard. Once that decision has been made, after 6 months after the petition was filed, either the trial ends, the proceeding ends if there's no decision to institute, so there's certainty within 6 months potentially, or if the decision is made to institute a trial, then the proceeding will take no more than 12 months after that decision has been made. And there's a series of briefs that are filed by both parties, briefs and discovery. Typically, you'll have depositions of expert witnesses. The patent owner can provide additional evidence and provide declarations of their own. And then ultimately, there is an oral hearing in front of the 3-judge panel. And lastly, the panel will issue a final written decision. Now, it's worth noting that the briefing schedule that's shown in this particular timeline is subject to some changes. The Patent Office right now, the PTAB, is engaged in a pilot program for motions to amend. So there is an option to choose a slightly different timeline if the patent owner wants to get additional feedback from the PTAB on their motion to amend. It effectively gives the patent owner 2 shots to try to get an amendment right and overcome the art that's been cited by the petitioner. Now, just a quick practical comment. In general, the petitions that are being filed at the PTAB are for inter partes review. Almost 93% of the total petitions have been for IPR. There have been about 500 covered business method review petitions filed, and only about 187 post-grant review petitions. Now, that all somewhat relates to the timing restrictions that apply to post-grant reviews relative to IPRs. Post-grant reviews are only available in the 9 months after a patent issues. Covered business method proceedings are limited to patents having a certain subject matter, and we'll talk about that. At the early days of the PTAB, the Patent Trial and Appeal Board, hovered around 87%. They did decline over time for reasons that nobody's quite put a finger on. A lot of people think that at the outset, the PTAB might have been very zealously killing patents. Alternatively, people have hypothesized that the patents that were being considered during the early days of the PTAB were of such low quality that it merited the high institution rates and ultimately the high invalidation rates at the PTAB. But you can see through this chart that over time, the number of PTAB trials that have been instituted relative to those that were filed, that institution rate has declined, and it now hovers in the low 60% range. The number that we have for fiscal year 2020, which just started in October, is probably not statistically significant just yet. Now, I mentioned earlier the timeline for a PTAB trial. I think it's worth looking quickly at statistics that relate to how that timeline affects the petitions that are filed. Of the 10,000 petitions that have been filed in all times, most are indeed instituted, as the prior slide would suggest. Those that are denied end at that immediate point in time. There's, of course, a couple of other categories that the Patent Office tracks, but the figure of interest is at the far right of the screen. It's this number of final written decisions, and ultimately also the number of those that break down where no claims are found to be unpatentable, roughly 20%. Roughly 20% also found to have some claims that are unpatentable. And a full 63% of the patents that are evaluated at trial by the PTAB are found to have all claims unpatentable. So there is a very high rate of claims that are removed, found to be unpatentable by the PTAB. Basically, in 80% of the cases that the PTAB hears, you're going to lose some of the claims once trial is instituted. So patent owners have a very, very heavy incentive to try to avoid institution of trial if they can. Moving ahead to the next slide, I want to talk more about the differences among the PTAB trial procedures. I've already mentioned the timing difference between IPRs and PGRs, and we'll talk about that a little bit further later in the presentation. It's important to note also that the type of patents that can be considered in these proceedings differs. So IPRs, inter partes reviews, and post-grant reviews, that would be the PGRs, apply to any type of patent, but a covered business method procedure applies only to claims that recite a financial product or service and which do not cover a technological invention. So there's sort of a relation there to the one-on-one analysis, and it ultimately does limit the types of patents that can be considered in a covered business method proceeding. Now, that has an impact on the type of art that can be considered during covered business method proceeding relative to inter partes review. And during an inter partes review, the only challenges that are allowed relate to novelty or obviousness under sections 102 or 103, and the art is limited to patents and printed publications. So similar scope of art that you would see in an ex parte review, for example. Covered business method proceedings, which are also available at any time, assuming the patent qualifies, have a broader scope, which is the same as the post-grant review proceedings. Those cover issues of both subject matter eligibility, novelty under 102, obviousness under 103, and any issue that relates to section 112, which would include indefiniteness or written description issues. Those post-grant reviews and covered business method proceedings also allow for a broader range of prior art. So you can get something more than patents and printed publications considered under those proceedings. So much like your supplemental examination that the patent owner can file for, post-grant reviews allow for a limited period of time at least. They allow a third party to get art in front of the office that would not otherwise be available through an IPR. And covered business method reviews include the same scope as a PGR with, of course, the restriction as to the type of patents. Now, there is one other important area of distinction among these procedures, that is estoppel. So a third party who files a petition for a PTAB trial of any sort is going to be subject to estoppel based on the art that third party raises. So that would prevent that third party from subsequently raising the same art, or in the case of IPRs or PGRs, prevents that third party from raising art that it reasonably could have raised in any district court proceeding or in any subsequent patent office proceeding. So that estoppel effectively serves to give the third party one shot, and then the third party is done, at least with respect to that particular art. Covered business method proceedings have a narrower scope of estoppel, so there is less art that's subject to the estoppel. Covered business method estoppel only covers art that was actually raised during that proceeding. So rather than that reasonably could have been raised standard that applies to the other proceedings, CBM estoppel is somewhat more narrow, which is another advantage of that procedure if the patent that is being challenged can fit within the relevant patent types.
Thank you for listening to this presentation, and we hope it has been helpful and informative. Since the America Invents Act, the AIA, became law in 2011 and was enacted in 2012, Fitch, Tabin and Flannery has represented clients in well over 100 AIA proceedings. Based upon the successful outcomes we achieved on behalf of our clients, Fitch was recognized in 2017 as the #1 firm in the United States for patent owners in IPR proceedings. And Fitch remains a top-ranked firm today. Most recently, Fitch was recognized in Petexia's 2019 IPR Intelligence Report among the top 25 best-performing law firms overall, the top 3% of firms representing clients in IPR proceedings. In that report, Fitch was recognized among the top 15 most active law firms representing patent owners in IPR matters. The members of Fitch PTAB practice group are available to answer any additional questions you or your clients may have. You will find additional information on our PTAB practice group and contact information at www.fitcheven.com. We thank you for taking the time to view this presentation.